Well, how do you feel about the government being able to get a hold of mass amounts of information about you in complete secrecy? Well, it happens, and a law from decades ago enables this to go further than you can imagine. A recent study from the Federal Judicial Center reveals that a federal docket that handles tens of thousands of secret cases each year. And what you may find troubling about these cases is that it allows for electronic surveillance. We're talking cell phones, email, and any other information stored on your computer or what you do online. Now, this is all regulated by the Electronic Communications Privacy Act of 1986, and privacy groups are saying this law is way outdated, especially since the way we communicate has evolved drastically over the decades. Many privacy groups are now pushing for this law to be updated. Well, to discuss this, Kate Crockford, Privacy Rights for Coordinator for the American Civil Liberties Union. Welcome, Kate. So how far can this law, it's the Electronics Communication Act, Privacy Act that is, how far can it go?
Well, I'm really glad that you mentioned that the law was passed in 1986. I was 3 years old in 1986. I'm sure many of you remember that if you were, my age at the time, cell phones didn't really exist. If people did have cell phones, they were about this big. They looked like bricks. People didn't use email in the way that we do now. Web chat didn't exist. Storing our information in the digital cloud was completely unheard of. These are things that we all do now every day. We live most of our lives in the digital realm. Our banking information is all online. Increasingly, our health records are online. We communicate very, very private and important information via email, via direct message on services like Twitter, via web chat, via Skype. Congress needs to update ECPA. I was 3 years old when ECPA was passed. It is now 2012. The world is a totally different place, and this magistrate judge's report is incredibly important because it really illustrates an aspect of what's problematic with ECPA that we hadn't been aware of previously. Judges are issuing these orders, he said up to 30,000 a year. Many of these orders are secret forever because if the government asks a magistrate judge for an order to read your email under ECPA, and they never charge you with a crime, you might actually never find out that government agents were reading your email. So we at the ACLU are part of a very large coalition. It's called the Digital Due Process Coalition. And it's not just civil liberties groups that are invested in changing and reforming ECPA. It's also companies like Microsoft and AOL and Apple, because these companies want people to trust the digital cloud. They want people to trust that when they put their information online, when they store it with third-party content holders like them, that it's going to be safe from government interference, if that's improper. So, it's not just us. There's a huge range of corporations and government advocacy groups that are calling on Congress to reform ECPA, and this report is just a very timely reminder and should shock Congress into action to do that.
As the legislation stands now, can the government obtain this information without a warrant?
So a part of the Electronic Communications Privacy Act is called the Stored Communications Act. And under the Stored Communications Act, there's a piece of that called, it's subsection D of section 2703, which basically allows the government to submit what's called section D orders. So it's actually, it's somewhere in between a warrant and a subpoena. A subpoena, as many of you probably know, is simply a form that a prosecutor fills out and submits to the holder of some content that it wants information from. No judge ever sees that order. A warrant is a much stricter standard. There are probable cause requirements for warrants. The Stored Communications Act D order sits somewhere in the middle. It's not exactly a warrant, it's not a subpoena, but what this judge magistrate's report shows is that the rules that ECPA put in place over 25 years ago are woefully inadequate, primarily because they don't allow even Congress, let alone the general public, to know how many of these orders are being issued, because there are gag, seal, and blindfold provisions which prevent people from even knowing how many of these orders are out there.
So what can be done now, and what parts of this law need to be updated in order to reflect, the times and the way that we communicate today?
Sure. So the judge magistrate, Stephen Smith, who issued this really important report, I encourage people to read it. You can go to my website, privacysos.org. The latest blog entry links to the report, and I talk about it. He basically is asking that Congress reform ECPA to mandate judges and judge magistrates to provide some kind of notice, ultimately, to the people who are targets of these orders. Because a key piece of what we need to realize here is that, my emails, the emails that I send to my friends, to my lover, my coworkers, whatever, I don't actually possess them. If I use Google or Gmail to send emails, it's Google or Gmail that possesses my emails. So the government doesn't even have to go to me. They can completely ignore me if it wants information about what I'm talking about or who I'm talking to, and go to Google instead. So there are a number of issues. One is transparency. We need to know how many of these orders are being issued. Another is accountability, so that, if a magistrate agrees with a prosecutor and issues an order for my communications information, I should be notified at some point so that I can challenge that order. Under ECPA as it stands, according to his report, people do not have the ability to challenge these orders. So, this is a very troubling situation in which tons of people are potentially being watched by the government without our knowledge ever. People might never find out. So there needs to be transparency, there needs to be accountability, and we need to update the law to reflect the fact that many of us use third-party content providers to spread our information around, to communicate online.
Okay, and to kind of wrap it up here, as you mentioned, kind of at the heart of this is transparency, the lack of transparency. How does this pose a danger to U.S. citizens, people like you and I?
Sure. I mean, it's pretty clear to us at the ACLU, and frankly to many Americans, that over the past 10 years since 9/11, there have been a series of laws, including the Patriot Act, which actually reformed a key part of the Stored Communications Act for the worst. That's sort of a more complicated subject, but many of these laws have essentially put us in a situation where the government of the United States of America knows far too much about us, and we know very little about what the government is doing. So that relationship needs to be flipped. We actually, as citizens of this country and of residents of this country, should be able to know what the government's doing, why. The government should be held to account for its surveillance practices. There are sometimes the government needs to surveil people. People break the law. There are dangerous people. Law enforcement needs to be able to do its job. But it's absolutely unacceptable for this kind of pervasive, long-term secrecy to prevail in a country of law.
All right, Kate, thank you very much. Very interesting, especially in this day and age. That was Cade Crawford, Privacy Rights Coordinator for the American Civil Liberties Union.